Right, hopefully we're back again. Session 6, the last one. Can I just point out, by the way, that if we sit like this, it looks like I'm in the distance because of Hannah's massive head, and she's in the foreground. Anyway, Ant and Dec are back.
And I'm delighted to have Andrew with me today.
Yeah, I'm sure you're not disappointed that it's not Carolyn. Right, we are going to talk about...
Sorry. Seamless start.
Common pitfalls and our experiences, as well as just picking up some sort of more random points that we haven't dealt with so far. For those of you who haven't yet sort of know who I am, or haven't yet know who I am, the most important thing is I used to be an engineer and a member of a pool team. Over to Hannah.
Good morning. I'm Hannah McNabb. I'm sure you all know that by now. I'm a partner here at Archor, specialising mostly in the dispute side of things, and I do a lot of adjudications. These are the partners, ARCHOR. If you don't know that by now, you need to watch the previous sessions. We have got an absolutely fantastic team here at Archer. This is actually an updated slide from last time because we've had some promotions. Liam's now a legal director. Lucy and Jess are senior associates, and Abby and Amy have started their training to become solicitors with us. So we've got a really brilliant team here, and it is so nice to see our staff excel in their careers. Right, enough of Archer, on to today's session. So this is the final session of our construction law training, and as Andrew said, we're just going to cover off some of these miscellaneous topics that we haven't yet covered and talk about our experiences and the cases that we've been involved in. So as always, as we're going through, if you've got any questions, just put them in the chat box, and if we've got some time at the end, we'll get to as many of those as we can. If not, we'll send a sheet round with questions and answers after the session.
Right, payment on account. I have to say the selection of what was left to talk was entirely sort of random. There's no logic to it other than these things we haven't picked up, and we see happening, we see issues arising with these things quite a lot. So payments on account, these really fall into two brackets. There's advance payments, and then there's the sort of trend historical approach to pay stuff on account for variations and stuff, and the consequences of what that can mean. Talking about advance payments, so JCT has an advance payment bond in the back. If you have, in the back of the document, if you ever read it, it basically says if you make an advance payment and you want the money back, you can have the money back. It's a bond, therefore basically would be given in because it's an on-demand bond, would be given by a bank. The issue is, why are you making an advance payment if you're a client? If you're a PM, why are you telling your client to make an advance payment? There may be good reasons for it, but query why you've employed a contractor who can't pay for it. There may be long lead-in items, and there may be a good reason for that, and I'll come on to paying for materials off-site. But the first obvious question is, why are you paying it? And if you are giving an advance payment, you should be very cautious about giving it without any kind of security to recover that money, because we are in a difficult world. Contractors are going bust. Be careful, essentially. The second point about payments on account is more the trend for people to sort of not decide whether something's a variation or not, and then saying, oh, well, I'll pay you, half it on account. There's pros and cons for either side to that. The problem is that every payment is an interim payment until the final certificate, final statement. So whatever is said up until until the final decision can be changed. And it would not be unheard of for certain subcontractors and contractors to be on sites thinking they've got agreement to various variations. A new QS arrives on the employer side or the contractor side at the end of the job and starts saying everything is nil. So that the first point is, from experience, be very wary of that. It can also work against the employer who's making these on account payments, because if they subsequently try and argue that it was never an instruction, never a variation, it's quite difficult sort of conceptually to say, well, I know I paid them some money as it went along, but it's not actually a variation. So it's just almost just be sensible about payments on account if you're paying ahead. And if you're talking about stuff as you go along, be wary that it could be changed. You get me for quite a while, actually. So I'm doing off-site materials as well, or materials more at this point. Now, materials on site, there is often a sort of suggestion that materials, do you pay for materials on site under JCT? And the answer is yes. Clause 413 makes it clear if materials are on site, there are certain requirements, but essentially, provided you haven't delivered every single material on day one, i.e. it's not premature, and if it needs to be protected, it is, then you are entitled to payment on site for on-site materials, and you are entitled to be paid for listed items that are off-site, which we'll come on to next. So materials off-site, there is a right to be paid, as I've just said, if it's a listed item or a non-listed item and the relevant parts of JCT are complied with. Essentially, what the contract says is you can be paid for materials off-site if you have a vesting certificate. Now, a vesting certificate is essentially a certificate from the supplier that says, I've got these materials, I've been paid, that you own them, Mr. Contractor or Mr. Employer, depending on what the system is. There has to be relevant insurance stuff, and that all works. The problem is people don't often do that, or if they do that, and I'll come on to this in a bit, maybe the vesting certificate isn't as genuine as you might have thought. And also the vesting certificate has to be signed by the supplier. It's the supplier who has agreed that it's vested in you. It's not the contractor in the middle, just because they've signed a piece of paper saying the supplier. So you need to be slightly careful with that. So materials offsite, I'll come on to the problems with it. But if you're going to do that, again, why have you employed a contractor that needs to do that? There may be a very good reason. There may be some extremely expensive cladding that needs to be paid in advance. That's fine. But if you're doing that, think about what sort of security you need. Now, the principles behind materials are actually quite interesting. Well, at least for a lawyer, at least. There are two key things. If materials are fixed, the law is very clear. The moment you've put some bricks in a wall, the law is very clear. If they're unfixed, then you get the interesting bit, because if they're unfixed, you then get a clash between the common law, the statutory position, and the contractual position. So what we're really looking at here is, and where this flares up almost all the time, is when someone goes into insolvency. So typical situation, contractor goes into insolvency, employer, there are some materials either off-site or on-site. Let's say, for example, they're on-site. The employer says they're my materials. Anyone who's been in this industry any length of time will know that a supplier will come along and say, can I have my materials back? I haven't been paid. So the situation is, who owns those materials? So just moving on to the next one, fixed versus unfixed. So this is the sort of overriding position. If, let's just say you've got a pallet of bricks and they're not fixed. Well, okay, then you get tricky. But if you fix those bricks into a wall, it doesn't matter who's paid for them, who thinks they own it. Once it's fixed into the building, then there is this Latin expression, quisquid plantator solo credit. Both me and Hannah did do Latin at school. In fact, I was thinking earlier, I did write down, arguably, I'm not sure I did English at my school. But anyway, what that basically says is whatever is attached to the soil becomes part of it. So there's no way you can argue that they're not, I can have, you sometimes get the scenario where someone says, I'm going to come down and take my brick wall. Well, that would be criminal damage. You can't do that because it's become part of the land, therefore it's fixed, therefore it doesn't matter about retention of title and stuff. You can get some quite interesting, again, if you're a lawyer, I suppose, some quite interesting examples about, well, what is fixed? Just because you've got a massive piece of machinery that's put on concrete, is it fixed or unfixed? If you're bolting stuff down, is it fixed or unfixed? But typically what we're talking about really is there's a bunch of materials on site. The supplier says, I haven't been paid for them, they're mine. And the employer says, well, I've paid the contractor for them, they're mine. So let's look at that. Unfixed materials. So the key with unfixed materials is whether it's a supply only contract or a supply and install contract. Now, essentially what that means is if you've got a normal subcontract where someone's come along, they do the materials, they fix it, whatever, or have you got your pure supply contract from Dewson's where they deliver a load of bricks? And the law is very different depending on the nature of that contract. If you've got a supply only contract, it's governed by the Sale of Goods Act 1979. This is when you put my glasses on. But essentially what 25 paragraph 1 says under the Sale of Goods Act, and take the employer as the person having bought or agreed to buy the goods, is if the employer has paid for them, even if it's to the contractor, they become the employer's, the employer obtains title to those materials, even if there is a retention of title clause between the supplier and the contractor, because the employer is unaware of that clause. So if the supplier had given that, if the supplier was giving it direct to the employer and there was a retention of title clause there, that'd be different. But the fact that the supplier's contract is with the contractor means the employer has no knowledge of the retention of title clause. So what the Sale of Goods Act effectively says is, because the employer has paid, as it says in here, has paid for the goods in good faith and without notice of any lien, which effectively is without formal notice of retention of title, the goods become the employer's, not the supplier's. This is even if the supplier has not been paid. And that does seem somewhat unfair, but that is the way the law works. For supply-only contracts, if the employer's paid the contractor, in your classic insolvency situation, the contractor won't have paid the supplier, the goods become the employer's. And however big the supplier's people are to turn up and pick up their white goods or stuff, they're not theirs. So supply only is very employer friendly. Moving on to supply and install. Now this is your classic subcontract. This is governed by a different piece of legislation, the Supply of Goods and Services Act. And this does not say the same thing. Back to Latin. Trying to think what they said in the life of Brian. Nautius Maximus. Anyway, back to Latin. So what the supply and install contracts or legislation says in Latin terms is nemo dat quod non habitet rule, which essentially says is one cannot transfer to another more than it has. Remember that. So even if the employer's paid the contractor, if the contractor never had title from the supplier because the contractor hasn't paid the supplier, the employer can't have title. Can you see the subtle difference? As far as the employer is concerned, there's a bunch of materials on site, they're mine. But they are only the employers if it's a supply only contract. If it's a supply and install contract, unless the contractor's paid for it and therefore obtained title, he can't give to the employer more than he's got. So you get this sort of weird distinction. The best way to talk about this is to have a question. So I have this sort of somewhat deliberate question where you have handcrafted ornate metal staircases. Supply only. Retention of title clause in the supply contract, fairly standard.
Do you just want to say what a retention of title clause is?
Are you suggesting I haven't made that clear?
I'd just...
So retention of title clause is basically a clause typically from a supplier says, I'm going to supply you these materials. I retain ownership of those materials until you pay me, essentially what the clause says. Sometimes you can get retention of title clauses that say title, i.e. the owner, the title to the person who owns the materials shifts on delivery, but most suppliers certainly won't have that clause. They'll have a clause that says you only get title to these materials once you pay me. And going back to what I said before, the supplier has that contract with the contractor saying you only get title once you pay me. Of course, the employer has got a clause in his contract that says I get them when they're delivered. Hence why the employer takes title, even though the supplier has got some agreement with the contractor that he doesn't. It's quite complicated. But taking this as an example, does the subcontractor retain title to the goods, if you read the example, in a situation where he's not been paid by the contractor, but the employer has paid the contractor? So And actually the answer to this question is, does a subcontractor retain title? The answer is probably no, because it's fixed. So it doesn't matter about all this other legal mumbo jumbo. If it's fixed, the title passes to the employer. If it was unfixed, but they're a supply only contract, then the employer takes title by virtue of the fact that they've paid for it. That's the first option. What happens if the employer has not paid for it? Well, if it's fixed, it doesn't matter. If it's supply only, if the employer hasn't paid for it, the employer never obtained title, because you have to, under the Sale of Goods Act, you have to pay for it to be able to obtain title. So in that scenario, depending on whether the employer's paid or not, it could be yes or no. But again, if it's fixed, it doesn't matter whether there's any payment or not. And perhaps the key point to keep reminding you is, if the employer's paid for it, the supplier can't argue that they get it back. The final way to demonstrate this is what happens if it's a subcontract, a supply and install contract. And your classic scenario is if the employer's paid the contractor, but the contractor hasn't paid the subcontractor, who owns the materials? Well, in that answer, it's not the employer, because the employer can't have title that the contractor never obtained. And because the contractor never paid the subcontractor for the materials, the employer can't take title. Have I made that more or less clear? I suspect I made that quite less clear. What I would say is material stuff, coming to the last slide, as I said right at the start, why are you paying for this? And bear in mind the sort of the trickiness that comes with this is, if you are getting to a situation where you're paying for off-site materials, or even on-site materials, make sure you've got the right security, whether you've got guarantees, whether you've got bonds. We did see, particularly when Ukraine hit, that there was an increase where employers were effectively having side agreements with suppliers direct, which is possible. You have a direct agreement where the employer pays the supplier direct, or in fact, the employer pays the subcontractor to pay the supplier. And there's a sort of direct contractual relationship between supplier and employer, making it easier for supplier to get the materials. The reason I've flagged this up a bit is that we've had two examples of one of our larger clients, about a year ago, where they were given false vesting certificates. So they were basically signed by the director of a contractor who's going bust, basically gave the impression that they'd already paid for the materials, and our client hadn't gone to check it. And of course, they hadn't paid for the materials. It was a made up vesting certificate, and all of a sudden, our clients paid over the money. I mean, you then get into situations of fraud and stuff. And as it turned out, in both occasions, the directors of the relevant companies panicked a bit, and it all got sorted because they were guilty of fraud. But, be wary of that. And the one other point to make is, which is, despite what all I've just said, is it does really often boil down to who's actually got them. Because unless you've got really expensive materials, the cost of trying to recover them is disproportionate to the actual value. And I did have a job years ago, would have been maybe 20 years ago, where the client says to me that a contractor's gone bust. And I said, "Oh, be careful, because, the suppliers will come and try and take their materials." And he said to me, "Well, there's nothing on site, just a load of guttering, etc." On the Monday, he says to me, every single thing on that site was stripped off the site. No one. So be careful that there's also always some value in materials, and basically the person who has it is likely to be the one, unless you've got something expensive. If you've got something expensive, you get into sort of interesting legal arguments about conversion, bailment. We're certainly not going to talk about them today. Now you get a bit of Hannah.
Thank you. So the next topic I just want to briefly talk about is the incorrect valuation of changes and variations. So Carolyn and I dealt with this briefly in session 4, but it's an issue that we see time and time again. So I thought it'd be useful just to recap what the JCT says about how to value changes to the works. So under the JCT suite, as you know, changes and variations are dealt with under clause 5. So the first consideration when valuing a change is whether an agreement can be reached on the value. So if an agreement can be reached, then this agreed sum should be applied for in an application for payment and then certified in a payment notice. It really is that simple. If you can reach agreement on the value, then we always suggest that this agreement is recorded in writing separately as well, just to prevent either party from trying to backtrack on that agreement a little bit later on down the line, which they can do if it's on an interim payment basis. As Andrew said, it's all interim until final certificate stage. However, more often than not, an agreement is not reached on the value of a change, so you need to look at what the valuation rules say in the contract. So for omissions, so if you're omitting work, the price is what's in the CSA, you omit that price. For additions, if there's any similar work in the CSA, then the CSA price for that work will be adopted unless there's been any change in conditions to depart from that agreed price. So if there's not any similar work in the CSA, then you have to use a fair valuation, so normally by reference to market values. And important to note that there's also an allowance for any additional or less design work, any additional or less site administration or facilities, and also any temporary work to facilitate the change. So just as a quick reminder as well, whilst clause 5.1 is not often amended itself, there are a few other amendments that can impact the valuation of variations. So for example, we talked in a previous session about condition precedent clauses. So if a subcontractor believes there's been a change, they have to notify the contractor in a certain amount of time. If you're getting to the point where you're talking about valuation of changes, make sure that these condition precedent clauses have been complied with. Otherwise, the entitlement to be paid extra sums is going to fall away. So look out for those type of clauses. They're a lot more common than what you think. Oh, it's you again.
Yeah, you can tell who read the slides, can't you? Right, provisional sums often misunderstood. You for the next slide.
Oh, sorry.
So, I mean, I'm old enough, did I tell you I used to be an engineer, to use SESM 3. There was a SESM 4, SMM 7 may have been up to SMM 8, was that? I don't know. But anyway, we're now talking about NRM 2 is the document that you look at for building, as to how you define provisional sums. Essentially, where provisional sums are concerned, it boils down to whether something is defined or undefined, because that triggers how you treat the provisional sum under the contract. I think the point to make is a provisional sum is not part of the works until it's instructed. It's, you know, the whole point is, yeah, there has to be formally instructed before it becomes part of the works. And under JCT 226.2, I believe, in D&B 2016, a provisional sum is a relevant event, 226.2.2, because it's an instruction under clause 311, and under clause 311, it is an instruction provisional sum. So any instruction provisional sum, subject to that being amended, is a relevant event. But that does not mean it's a delay event. It just means it's a relevant event, because what it is essentially is a change to the works. What do we mean by defined and undefined? Well, that on the slide is the NRM definition, but essentially it really boils down to one that is definitely going to happen, and therefore there should be enough information for you to know it's going to happen, and one that you may choose, that the client may choose to instruct you. And the relevance of this is that the relevance of this is that if it's a defined provisional sum, you are meant to have allowed for it in your program. So, and the best examples really are, you know, power to a new site. You are going to have power to a new site. Otherwise it won't work. So whilst it might be a provisional sum because you don't know how much it's going to cost, and therefore that, you know, they tend to leave that open-ended, you have to have allowed for that in your program. An undefined provisional sum, probably a good example, is kitchens. If you're building residential, often the employer may want to employ a kitchen fitter direct, kitchen supplier direct. So the idea that the kitchens may be put in by the contractor may be a provisional sum that is undefined. They haven't really defined exactly what they want, So you don't have to deal with that in your program. So if in the event that undefined provisional sum is instructed, that will have a bigger program effect than a defined one, because you should have already allowed for it. I'll come on to the fact that the fact you've already allowed for it is one thing. So you can't get a relevant event for the mere, you can't get a delay event for the mere fact you've been instructed for a defined provisional sum. But often it boils down to when you've been instructed for it. So for provisional sums, as NRM says, you should have assumed it's going to be programmed, and you should have priced in your prelims for a provisional sum. It's for a defined provisional sum. Now, NRM says, to the extent the provisional sum is not very well defined, it should be treated as undefined. I can tell you now that almost every contract says all provisional sums shall be treated as defined. So when you get that sort of amendment in your contract, you've got to have allowed for undefined as well as defined being instructed. As a contractor, the best way to manage this is to be clear on your program that you need an instruction on these provisional sums by a certain date. If that doesn't occur, but it occurs later, you'll be entitled to a relevant event, not because it's a provisional sum, but because it's a change that is late. And that's why it matters, because you have to allow him for one and not the other. That's my red herring. There is a current trend that we're seeing in contract amendments where employers are seeking to cap provisional sums. Now, the idea of a provisional sum is that you get paid, there's a figure, which is roughly what it will cost. But when you actually carry out the work, you get paid the cost plus an agreed overhead and profit. Because how can you price something, you don't know what it is? We're seeing a trend towards employers to say, well, we've got a figure in the contract for provisional sum, that's a cap. I mean, that's a sort of, you shouldn't be accepting that, because it's like a cap for something that's not clear. We're seeing some contracts where they remove the right for a relevant event if it's a provisional sum. Again, that doesn't really work legally either, because if someone does instruct a change, you have to have the right to an extension of time. And we're also seeing that, because where provisional sums are concerned, overheads and profits should be treated separately. They shouldn't be included as part of the provisional sum. And we're seeing that all merged in. So what we're seeing is employers trying to limit the scope for provisional sums to get out of hand. I mean, the truth is they shouldn't have as many. So just watch that in the contracts you're getting sent through. But as I said earlier, the typical issue with a provisional sum is not that you instructed it, because that's a relevant event. But if you instructed it on day one, it's not going to cause you a delay. The typical problem with a provisional sum is that it is instructed at some point, but the employer's taken too long and chooses to instruct you to carry out that provisional sum at a later date. So the fact that you've allowed for it in your program doesn't prevent you getting an extension of time if it's instructed late, because your program assumed you'd be instructed by a certain date. You've been instructed 3 months later. Well, guess what? That will cause potentially a 3 month delay. So even if you're meant to have allowed for it in your program, sometimes you get the other side say, well, you've allowed for it in your program, there's no right to extension of time. Now, you've allowed for it in your program, assuming it's instructed by a certain date. And so this sort of red herring that you don't get an extension of time is often just not right. It's just a late change.
Oh, it's me. So I bet you were wondering when we'd start talking about smash and grab adjudications in this session. Well, here we are. A common pitfall that we see pretty much every day is out of time payment and pay less notices. So first up, can a late payment notice take effect as a pay less notice? So according to the TCC, it cannot. So there was a case that came out late last year, and that was Vision Construct Limited and Dipcraft Drylining Contractors Limited. So here the court held that it was an ambitious submission to try and claim that a document was a pay less notice when it was clearly labelled to be a payment notice. The quote from paragraph 44 of the judgment is particularly helpful, and I've put this on the slide. So the paying party tried to argue that the out-of-time payment notice could take effect as a pay less notice, but the court disagreed. So a word of warning on this point, as we always say, get your notices issued on time to avoid any smash and grab adjudications. So what needs to be in a payment notice? Well, it's the sum considered to be due as at the due date and the basis of how that sum has been calculated. This doesn't need to be overcomplicated, and quite often the easiest way of doing this is for the payment notice to mirror the application for payment with just the paying party's values in there. We'll say the same about a pay less notice. It is the sum due as at the date the pay less notice is served and how that sum is calculated, and that needs to be clear in the notice for it to be valid. Something we quite often see is parties submitting a document that's called payment notice / pay less notice to try and get it to take effect as either or for the purpose of the payment cycle. In my view, this is risky, particularly in light of this case. Mark it as a payment notice or mark it as a pay less notice, and make sure you know what your contract says and that it's issued on time.
Before you go on, just as a sort of anecdote, I've had 2 adjudications where undoubtedly the other side have a document called payment certificate, and at the bottom have a note that says, they actually have words withholding, bizarrely, and that's clearly not a valid pay less notice or payment notice because it's mixing the two. And on both occasions, the adjudicator said it's fine. So notwithstanding the law, you still get this, uncertainty. That the main point, as Hannah said, is get them in and get them in properly, and then you don't get any uncertainty.
Can I carry on?
You can, yeah.
Thanks.
Just for a bit.
Thank you. So I'll come on to the RBH and James case later. Just as a point to note, though, this has been heard in the Court of Appeal, and there was a remark from Lord Justice Coulson that he made during that hearing that he's not a fan of the procedural adjudications, and he apparently noted that Parliament didn't intend for smash and grab adjudications. We'll need to wait and see what he says in his judgment, which is due imminently. But this could perhaps be the start of a shift in the landscape for smash and grab adjudications. We don't know yet, but we'll have to wait and see. So watch this space. Until then, there's just a few cases that I've put up on the slide that have come out recently with regard to payment notices. First is Place First and CAR construction. So here the court held that a pay less notice can be issued at any time after the notified sum arises. So CAR tried to run an argument that the pay less notice was invalid because it was issued too early, and the court said no, that's absolutely fine. The Lang O'Rourke case on the slide was handed down just a few weeks ago. Here the court held that even where the payment notice was invalid, this did not automatically invalidate the related pay less notice. So the payment notice is out of time, but a pay less notice is then issued, and that is the pay less notice is issued correctly, the pay less notice will still have effect despite the fact that the payment notice might have been invalid. I'm just really flagging this to show that smash and grab adjudications are still rife in the industry. Parties are still not issuing notices on time or correctly. If you're a party that's claiming payment, a smash and grab adjudication is the easiest way to recover your money, as the adjudicator can only look at whether your application is valid and whether a payment notice or pay less notice has been served. The adjudicator can't look at any value of the works, delve into anything like that. It's just the issue of the notices. So if you're a paying party, it's really important that you understand the contract and you know when notices have to be issued and what they need to say. It can be a really expensive process if you lose on a smash and grab and you've got to pay a load of money out and then run a true value adjudication to try and claw any of that money back. That was quite bossy, wasn't it? I'm talking about termination. So termination is another really hot topic. Again, I know this was covered in session 4 that I did with Carolyn, but it's something that we're seeing a lot of. And lots of arguments of wrongful termination. So it's really important that if you're terminating, you get it right. There's also some general confusion about when payment is due post-termination. So I'm going to cover this point too and briefly touch on insolvency as well. Firstly, I just want to talk about the Supreme Court judgment in the Providence and Hexagon case, because this was handed down just after session 4, so we didn't talk about it. So I'm just going to quickly cover off what the Supreme Court said and the impact this is going to have on JCT contracts going forward. So the case concerned a really short but important point regarding the correct interpretation of the contractor termination clause in the JCT 2016, and it's also mirrored in the 2024 standard form in a D&B. So the facts were the works concerned a number of apartment blocks that Providence was contracted to design and build for Hexagon. Their former contract was a D&B 2016. So works were carrying on. Interim application 28 had a final date for payment of the 15th of December 2022. Hexagon didn't pay that date. So the following day, the 16th of December, Providence issued their notice of specified default on the grounds that Hexagon had failed to pay the amount due by the final date for payment. So there'd been an amendment to the standard JCT that then said if a notice of specified default was being issued, Hexagon had 28 days to rectify that. The standard is 14, but it's been extended to 28 days. So if Hexagon did not rectify it, so if Hexagon didn't make payment within 28 days of that specified default notice, then Providence would terminate, which they were entitled to under the contract. So Providence served this notice of specified default, and Hexagon then did make payment within that 28-day period. So there was no entitlement for Providence to rely on non-payment to allow them to terminate their employment under the contract. So that all got sorted. Works continued. Interim payments were then made in accordance with the contract until they got to interim payment application 33. So once again, the application went in. Hexagon didn't make payment on or before the final date for payment. So the following day, Providence issued their termination notice. So not another default notice, they just went ahead and terminated. And they relied on clause 894 of the contract, which I've put on the slide. So Hexagon challenged this termination, saying it was unlawful. Hexagon said that to validly terminate under this clause 894, Providence must have first accrued the right to terminate under clause 893. Now, Hexagon said this never arose because Hexagon had made payment within that 28-day period set out after the specified default notice was served. So that was Hexagon's case. Providence said that they didn't need that right to accrue because they relied on the words "for any reason" in 894, and they said that that included a situation whereby the right to terminate hadn't actually arisen. Providence said that all that they needed to show was that there was a repeat of a specified default, and that specified default was the failure to make payment by the final date for payment, and that in itself entitled Providence to terminate. So they toddled off to adjudication. Hexagon's argument won adjudication. Hexagon's argument also won when it went to the Technology and Construction Court. However, Providence sent it up to the Court of Appeal, and Providence arguments won in the Court of Appeal. So Hexagon then took it all the way to the Supreme Court for determination. And this made us all very excited because nothing ever really goes to the Supreme Court. So everyone was very keen to hear what the Supreme Court had to say on this. But perhaps unsurprisingly, the Supreme Court did find in favour of Hexagon. I think the Court of Appeal decision was a bit of a shock to a lot of us in the industry, but the Supreme Court seemed to have reined it all back in again. So the right to terminate must first have accrued under clause 893 to allow termination to take place under 894. The court clarified that 894 deals with a situation whereby the right to terminate has arisen. So if Hexagon hadn't made payment in that 28-day period for the previous application, but for whatever reason, the right had not been exercised. So what do we take away from this? Well, in really simple terms, if you're a contractor that receives payment late, the safest way of dealing with it is to make sure that each payment has its own default notice. So make sure that you've got the right to terminate before you do actually terminate. Otherwise, your termination is going to be deemed wrongful. So what happens if the contractor terminates wrongfully, as Providence did here? Well, the most likely scenario will be that the contractor will be in breach of the contract, not the employer, despite the fact the employer made the payment late. And the contractor will be liable to the employer for all losses that flow from that breach. So these could be really substantial. Think about additional costs of completing the works with a new contractor, as well as delay costs, any financing charges the employer might have, and they won't be limited just to liquidated damages in the contract. There'll be no cap on these. So if you are terminating, you really need to make sure you're doing it properly. And it is such a tricky area. We're seeing it all the time at the moment. And there's lots of arguments on wrongful termination. So just check you know what's in your contract.
Without wishing to jump in again.
That's fine.
What this also allows employers to change that period for 28 days, pay on day 27 each month, and not have any consequences.
Yeah.
You can suspend after 7, for example, but not have any consequences. So again, when it comes to terms that you're looking at, make sure that if those sort of things are changed, you factor in the idea that you could be in a situation where the employer just decides to wait 28 days each time they pay you. Sorry, that's just me.
No, that's a useful point. Right, another reason why termination could be deemed wrongful is that the notices are not served correctly. So please check what your contract says before issuing any default as well as termination notices. I know we've covered this in session 4, but I cannot stress the importance of this enough. So I'm going to keep banging on about it. So if the contract says that notices need to be served in writing or be sent by special delivery or by hand or by carrier pigeon, make sure you comply with these provisions. If you don't, the likelihood is that the default and termination notices won't have been served correctly, which will mean the termination is wrongful. And I've had this before where the contract clearly says for the notices to take effect, they have to be issued by hand or special delivery. Contractor just sent them by email. Adjudicator found that was wrong. So really check what's in your contract first. Also, just another point to note, if you do issue a specified default notice, it's not deemed to have been received until the 2nd business day after posting. So you've got to take this into account when you're calculating the 14-day period of the specified default continuing to occur before you can terminate. So you don't want to terminate early, as this will likely be a wrongful termination. You're in breach and you've got to pay the other party's losses. So just check your termination provisions correctly, make sure you're following what it says, make sure you know when it's deemed served and you've got that 14 clear days before you do actually terminate. Just quickly on termination payment and the payment that flows post-termination. So before the 2024 version was released, there was some confusion about payment dates and when notices were required in relation to payments post-termination. So this has led to some parties adopting a position which is probably correct, that the scheme applies. And as you'll know from session 2, there's a very small time frame for a paying party to serve payment or pay less notices to avoid a smash and grab adjudication. So JCT sought to tackle this head on in the 2024 version and included this new clause that said what happens after termination and the payment. This is quite often amended, so the time periods are usually extended, but if you've got a 2024 version, check what those time periods are. If you haven't got a 2024 version, chances are it doesn't say anything about payments post-termination. So if there are no terms about these payments, the scheme is likely to apply. You've got a very short time to put in your payment or pay less notices. So understand what your contract says on this before you terminate. Final point on termination I just want to briefly cover is around when a party can terminate because of the other party's insolvency. This is something we are seeing so much of at the moment. And you see what happens. Rumours are rife about a subbie's solvency. They've got just enough men on site to do some work, but not really enough. You know they're going to go bust, but there's nothing filed at Companies House, nothing filed at the court. If you terminate, though, before there's any formal insolvency procedure, you're likely to be in breach. So if you're going to terminate for insolvency, you've got to first check that the other party is actually insolvent as defined in the JCT. So JCT lists out what the definition of insolvency is and when it applies. But a really important example of this is in relation to a company that's entering into administration. So at the point in time the company enters into administration, then it is insolvent for the purposes of JCT, and that would allow the other party to terminate. However, the entering into insolvency is when the appointment of the administrator takes effect. It is not when the notice of intention to appoint an administrator is filed with the court. So you're in this period where the company has issued their notice of intention to appoint an administrator, but you still can't terminate because no administrator has been appointed for the purposes of the JCT definition of insolvency. So this can be really problematic. They're off-site, they're not doing any work, but you're stuck, you can't terminate. So just as a thought going forward, you may want to amend your contracts just to allow for termination to take place the minute a company files with the court a notice of intention to appoint an administrator, just to avoid this period. But the key to this really is if you're going to terminate for insolvency, check that the other party is actually insolvent and falls into the definition within the JCT.
Right. So this is the final stretch of the final session, although I will come on to some exciting news going forward. But anyway, so we're going to talk a few cases that we've been involved with, either directly as individuals at other places, or
places that can't be named,
or at Archor itself. They don't necessarily, we haven't won them all, but what they have all done, somewhat bizarrely, have shaped the way the law is running, and it was just more to just give you some experiences and to highlight those. So there's 5 cases on there. Strangely enough, Hannah's going to do the first one.
RMP and Chalcroft. Andrew and I worked on this case at the place that can't be named, and it was quite a long time ago now, but it still comes up quite frequently in submissions. So we had a smash and grab adjudication that we won. We acted for RMP, the subby. Chalcroft was the main contractor. So Chalcroft didn't pay, so we sought to enforce the decision in the TCC. The contract on this one was a complete mess. There were emails flying around, draft documents. It was all over the place. So we argued that the contract was formed by way of an email from Chalcroft to RMP that was subsequently accepted by RMP, and that formed the contract. So Chalcroft said there were actually 3 alternatives as to what the contract was. They said that it was either a letter of intent, or it's a letter of intent that contained clauses in an email, or a letter of intent that incorporated a JCT. So it was all over the place. So when we got to the TCC, the judge, Mr. Justice Stuart Smith, he enforced the decision, which was great for us. He found that whatever route you took, whether you used our interpretation of the contract or whether you used Chalcroft's interpretation of the contract, the route for adjudication was the same. It was the scheme, and there was no adjudicated nominating body in any of those forms of contract. So it didn't matter really what the contractual arrangement was. The procedure for appointing the adjudicator and the procedure for the adjudication itself was the same. He also agreed with RMP's interpretation of the contract, which meant that the pay less notice was late, and the adjudicator's conclusion that RMP was entitled to the sums that it applied for was correct. However, he did agree that if one of Chalcroft's arguments regarding the contract was correct, the pay less notice would actually have been in time and it would have been valid, and therefore RMP wouldn't have been entitled to the money. We said that once the adjudicator had jurisdiction, the fact that the different contractual interpretations may have led to a different substantive outcome was irrelevant and not a bar to enforcement, because the court's not going to look at whether the adjudicator just got the decision wrong. The court's going to look at, is it an enforceable decision? And the judge agreed with that. So the fact that the adjudicator may have got it wrong doesn't really matter. As long as he had the correct jurisdiction to make his decision, which the court found that he did, then the decision will be enforced, which it was.
But I should say it was quite unusual because this is 14 years ago, and it's still not 14, it's 11 years ago. It's still good law. But the one sort of caveat to it is it's good law because it was whichever form of interpretation you always came back to, you had to use the scheme. If even in a scenario where you had a contract or a potential contract that said it referred to, I don't know, Texas, or a no contract, in which case you use the scheme, what you'd need to be careful of is to make sure, in that scenario, you wouldn't be quite so confident of the outcome because you might choose the wrong one. So it's good law, but only where basically contracts are a complete mess. Perhaps the most famous one, where we acted for the party that lost. But as I said at the time, I knew we were right. It just took 6 years for someone to say so, at S&T and Grove, but ISG and Civic. Now, ISG and Civic was effectively your starter for the smash and grab world. I don't think people knew it at the time, but it was. What was happening at the time was if someone missed a payment notice or pay less notice, and the other side would say, I'm entitled to the money, the paying party would immediately issue a true valuation adjudication. You'd get the correct answer and everyone would move on. In this case, ISG applied for 1.1 million. I should say, actually, it's interesting. If you look at the previous example, both those parties have gone bust. You look at this example, the contractor's gone bust. You look at another example we're coming on to, someone's gone bust. There is a theme here of people who go very aggressive with legal cases. Civic haven't, because they're a public body. Well, ISG applied for 1.1 million. The contract administrator didn't deal with it properly at all. And so they said they're entitled to 1.1 million. We went off and had it valued by the late Bob Juniper, who died a couple of months ago. He was a very sensible chap. Went off and had it valued, and he said it was worth 300,000. And the way it had been up until that point was everyone agreed it was 300,000. Let's move on. ISG didn't. Went to court, and the judge and I shall say this till the day I die, that I thought we had won until half hours to start speaking, and then we lost. The judge basically said, now hold on a minute, the notified sum, effectively you have to pay the notified sum. And where ISG was concerned, because the judge said the only way payment can be made is from employer to contractor, the only exception to that is at the final certificate stage, meant that not only did you have to pay the contractor straight away, you couldn't recover it for 12 months or 15 months or whenever the final certificate was at that point. And that was a sort of bit of a shock, because if you missed it after PC, you couldn't get it back for another year. What's happened since is the principle that you have to pay first, which we'll come on to again, remains the case. In fact, if anything, that's got even more extreme. So you have to pay a notified sum first. So ISG said that. What has changed is, whereas ISG said there's no right to get payment back, S&T and Grove in the Court of Appeal said, no, they're completely different disputes. One is about a notified sum, one is about a true value. So once you've paid the notified sum, you can immediately apply for a true value. So one of the principles remains correct. You have to pay it first. The period over which you can get it back has changed drastically, and they get it back straight away. You still run the risk, of course, if you pay someone in the interim and have to pay them first, they could then go into insolvency and you can't recover it. But it's not, ISG and CVIC is partly still right and partly not.
Henry and Alifix. So we acted for Henry in this case, another smash and grab situation. Facts are as follows. So this was a post-termination application for payment. Alifix was a subby, Henry main contractor. Alifix applied for payment, and after the final date for payment had passed, started a smash and grab adjudication against Henry. So Henry argued that it submitted 2 valid payless notices and defended the smash and grab adjudication on that basis. Whilst that smash and grab adjudication was ongoing, Henry also started its own true value adjudication. Now, Alifix argued that the second adjudicator should resign, as Henry had not discharged the payment obligation, and as such, that second adjudicator didn't have jurisdiction. The second adjudicator dismissed this challenge because there'd been no decision in the first adjudication, so it wasn't certain that Henry hadn't discharged the payment obligation. During that second adjudication, Alifix won the first adjudication. And what happened here is, rather than resigning, the second adjudicator said, well, I'm going to stay this adjudication to allow payment of the decision in the first adjudication to be made. So Henry had to pay that notified sum. So the adjudicator stayed or paused that second adjudication. Henry made payment to Alifix. And then once payment was made, that stay was lifted and the true value adjudication continued. So in the second adjudication, the adjudicator decided that a substantial amount of money was due to be paid back to Henry. However, Alifix resisted enforcement on the grounds that that second adjudicator didn't have jurisdiction, because at the time that Henry started the adjudication, it hadn't discharged the payment obligation. Unfortunately for Henry, the judge agreed with Alifix's position. So the immediate payment obligation fell on the final date for payment, not the later date of the adjudication decision that decided that there was this payment obligation that existed. I'm not bitter about losing this case, but when you take a step back and consider the position commercially, it does seem bonkers that Henry paid Alifix the notified sum. So Alifix had that money, yet it wasn't able to recover the overpayment when considering the true value, simply because of the timing of when Henry started the adjudication. However, I'm not a judge in the TCC, so what do I know?
I was just going to say on this, firstly, for those of you that were had any knowledge of Henry construction, this was not the straw that broke the camel's back, by the way. The amount of money we were talking on this week was not the reason Henry went bust. So that's the first point. And also, Hannah is not a TCC judge because there's been 2 cases since that have confirmed that this was right. Beck's Heat and Essex Services and AM Construction, the Durham and Trust. But recently, it's been taken to another level. So the basic position is if there's a notified sum, whether there's an adjudication or not, you have to pay it, which is bizarre because you might argue that it's not a notified sum, isn't due. Or the recent case of VMA Services and Project One Limited was when there was a payment application, no payment notice, etc., but the contractor hadn't done anything about it. The client starts a true value adjudication, thinking, "Oh God, I've missed all this. I must start one." As part of the adjudication, the contractor's defence was that I'm entitled to the money under a sort of no payment, no pay less notice. So even though the client said, "Please give me a true value," the adjudicator actually decided whether there was a valid application, whether there was any payment, as there wasn't, actually decided in favour of the contractor, and just decided in favour of the contractor's application. Didn't consider the true value because he said, once I've decided the application is valid and it's due, I have no right to consider the true value adjudication. That's gone off to the court, and the court said, yeah, that's right. So it's
quite extreme, isn't it?
You can now use a lack of a payment notice to defeat a true value adjudication by saying, well, they can't even do that, and by the way, award me the money. And the court said that's fine. Basically saying, if you miss a payment notice, you're in trouble. We've only got a couple of minutes.
We'll whiz through these.
Jarvie and Fincham is a very, it's got a lot of publicity about WhatsApp messages that form contracts. The underlying point is a WhatsApp message or social media type messages can form contracts. Is it true to say that WhatsApp is social media? It's almost the same as text. In fact, WhatsApp is almost more common there than text message. So WhatsApp can be used as an evidence for a contract. It's slightly taken out of context because if you actually know the facts, there was a initial, can you give us a quote? There was a quote. So there was almost a contract anyway. And then there was these WhatsApp messages agreeing final parts of the contract. But the point is WhatsApp and those sort of things can form a contract, but they do create a level of uncertainty because you don't often put in a WhatsApp message, "Oh, and by the way, pursuant to clause 8.6, can we have the word reasonable?" So just be careful about that.
The last case is RBH and James. Because it is now 9:30, I'm not actually going to talk about this because it might all be wrong in a few weeks anyway, because as I said earlier, it's gone to the Court of Appeal and we're waiting for the judgment to be handed down. So who knows, this might change the whole view of smash and grab adjudications, given that Lord Justice Coulson doesn't appear to like them. But it's just one to look out for. We'll obviously be issuing articles when the Court of Appeal judgment does come down. A couple of interesting points though: validity of a pay less notice and also the residential occupier exemption. And when Mr. and Mrs. James first bought the property, apparently they were going to live in it. They then decided they wanted to redevelop it and never live in it. We argued that therefore they're not a residential occupier. The court said no. At the time the contract was entered into with the contractor, our client, they were a residential occupier, so the Construction Act didn't apply. So a couple of really interesting points that will come out of that, hopefully in the next few weeks when it is handed down. Just another example of a case that we've been involved in and we've been working on.
So that's
bang on 9:30.
That's the end of the 6 sessions. The exciting news, albeit not till the autumn, we're going to do an NEC equivalent, probably only 4 sessions. Hannah is not bursting to do NEC because she's not.
It's not going to be me.
But we're going to do 4 in NEC as well, just to, and the whole point of these sessions, partly obviously so everyone gets to know who we are, is to build up a sort of a level of legal knowledge for commercial people. I would encourage commercial people, if they want to be a lawyer, go off and be a lawyer. If you want to be a good commercial person, understand the law, but be a good commercial person. Don't turn into a lawyer, because one, we're really dull, and two, you make much more money if you understand it rather than try and use it against others. So that's it. But hopefully you'll be keen to sign up to the NEC ones when we let you all know.
And any questions at all, just email them over to us. And thank you very much for joining us. And if there's any sessions that you'd like us to present in the future, just drop me an email and let me know. We're always keen to hear about other sessions that you'd be interested in hearing on. So yeah, that's it from us.
Okay.
Thanks very much.